Thank you very much to everybody for attending this talk. Why a shorter introduction to competition law? Well, the trigger for this was a conversation I had with Duncan Macpherson a couple of weeks ago, who was looking for a competition junior and couldn't find one for love nor money. If one looks at the weekly updates that come from the law reports people, there seem to be 2 or 3 competition law cases being reported every week. And there's the statement from the president of the Competition Appeal Tribunal, which I quoted in my original email about this talk, saying that the tribunal was inundated with private claims of all shapes and sizes. So there is work out there. Competition law, in my view, is nothing to be scared of. And if there's a theme to this talk, it is that it's all really straightforward. So the structure of the talk is going to be a brief look at the history of competition law, moving on to a summary of the main statutory and regulatory provisions, and then moving on to the headline points concerning competition law, and including an introduction to a few crucial jargon-filled concepts. So, one of the higher order intellectual questions is said to be, how do we get here from there? The starting point for that, when it comes to competition law, is probably the Statute of Monopolies from 1623. So, point 1 on the screen is in fact an edited version of section 1 of the Statute of Monopolies. Amazingly, it's still in force. All monopolies for the sold, buying, selling, making, working, or using of anything within this realm or the Dominion of Wales are altogether contrary to the laws of this realm, and so are and shall be utterly void and of none effect and in no wise to be put in use for execution. What I haven't put up there, because it's very long and no longer in force, is section 4 of the Statute of Monopolies, which created a cause of action at common law to the victims of any monopoly and included the penalty of the victim should recover 3 times so much as the damages which he or they sustained, triple damages. And although this is 400 years old, effectively the remedy for anti-competitive behaviour remains an action for damages for breach of statutory duty. Now, moving on in the historical development, we go to the United States of America. The Monopolies Act really was directed towards the last vestiges of feudalism rather than capitalism in its modern form. But the Sherman Act of 1890 is the United States trying to get to grips with rampant predatory capitalism. And it's the first modern statute that I'm aware of aimed at anti-competitive behaviour. There is a dichotomy that will be seen in other legislation between Section 1 and Section 2 of the Sherman Act. Section 1 is directed at contracts, combinations in the forms of trust or otherwise, or conspiracies in restraint of trade. So the modern word for this would be cartels. So it is businesses combining together in some way to impose higher prices on the public. Section 2 is specifically against monopolies. So monopolies here are just thought to be a bad thing. We don't see the later, slightly more nuanced approach that can they justify themselves in some way. Section 7, I just put in there for interest, just to show how the Sherman Act followed on from the statute of monopolies, because we still see there treble damages at the end, and shall recover threefold the damages by him sustained. The Sherman Act in a slightly modified form still exists and is one of the main anti-competition abuse acts in the United States, and you still get triple damages. Just out of interest, the word trust in Section 1 does mean a trust. The way that the early United States capitalists organized themselves would be they would have a trust as a holding company. You will often hear the word antitrust used as a synonym for competition law. And in modern competition law, there are no trusts involved to the anti. But where this phrase originally comes from is from the United States, and it was trusts which they were getting at. Moving on to Europe. In fact, before we move on to Europe, I should briefly say that there's no action going on in the United Kingdom for most of the 20th century. Either anti-competitive behaviour was just not thought to be a problem, or nobody cared very much. There was a now forgotten Restrictive Practices Act of 1956, which was a sort of half-hearted attempt to deal with agreements between companies, i.e. the cartel side of things. But it was essentially toothless. Modern competition law begins with Articles 85 and 86 of the Treaty of Rome, which are now, with almost no change in wording at all, Articles 101 and 102 of the Treaty on the Functioning of the European Union. So there is a similar dichotomy here as we saw with the Sherman Act. Article 101, agreements between undertakings, concerted practices, this is aimed at cartels, cozy agreements between businesses which result in the raising of prices. Article 102 is aimed at quasi-monopolies. Quasi-monopolies because in a slightly more sophisticated view of the economics of the situation, it's the dominant position within a market which is perceived to be the risk. And abuses of the dominant position are the vice at which Article 102 is aimed. So what are abuses? Well, there's a list of them. It's quite a long list, so I didn't put it on the slide. But they are directly or indirectly imposing unfair purchase or selling prices or other unfair trading conditions, i.e. raised prices. Limiting production, markets or technical development to the prejudice of consumers, or limiting production and markets results in artificially inflated prices. Third one is applying dissimilar conditions to equivalent transactions with other trading parties, placing them at a competitive disadvantage. In other words, trying to get rid of your competitors or potential competitors, making the conclusion of contracts subject to acceptance by other parties of supplementary obligations, making it more difficult for other people to enter the market. It's not an exhaustive list, and the abuse of a dominant position and market abuse generally is like fraud, an ever-changing thing. Moving back home, we see the Competition Act 1998, and I've got the wrong slide up and can't get the right one. So let's start with chapter 2 prohibition. Well, if it's a chapter 2 prohibition, it implies it's a chapter 1 prohibition. And the chapter 1 prohibition is found in section 2 of the Competition Act. I'm sorry, there's no slide, but if there were a slide, you would see that it replicates very closely Article 101 of the Treaty on Functioning of the European Union for a very good reason. It was intended to. It was largely written across. Now that we've left the European Union, the Competition Act 1998 is the main statute when it comes to trade in the United Kingdom. The Chapter 2 prohibition is the one up on the slide. The Chapter 1 prohibition is cartels, agreements between undertakings, and concerted practices. The Chapter 2 prohibition is abuse of a dominant position. Okay, bear with me while I just try and sort out the slides here. No, looks like we're stuck with. Oh no, there we are. Now, as I said, one of the themes of the talk is that competition law is essentially simple. And one of the delightful things about it is that the legislation is relatively limited. We have the Competition Act 1998 with the Chapter 1 and Chapter 2 prohibitions. That is the essence of competition law, those two prohibitions. The Enterprise Act sets up the Competition Appeal Tribunal as a specialist court. The Enterprise and Regulatory Reform Act 2013 sets up the Competition and Markets Authority, and the Competition Appeal Tribunal rules set out the rules for the Competition Appeal Tribunal. The number of statutes and statutory instruments that one has to deal with is limited. Now, just by way of short explanation, the Competition and Markets Authority is the investigative policeman of competition law. They are the people that investigate Apple, Google, those sort of things. The Competition Appeal Tribunal is just a court. They share judges with the Chancery Division. There's specialist economists that sit there. But it's just a court. It's just a court designed to have some specialist expertise in competition issues. Litigating competition law is therefore, in essence, quite simple. The claims are all ultimately claims for a breach of statutory duty, and the statutory duty in each case is either the Chapter 1 prohibition duty, not to enter into agreements preventing, restricting, or distorting competition, or the Chapter 2 prohibition, the duty not to abuse a dominant position. The course of action is just going to be one of those. Couldn't be more simple. However, there's always a however. Major cartels are, as a general rule, highly professionally organised and extraordinarily secretive, and few victims of a cartel have the resources all the time to investigate the existence of a cartel and put together the evidence required. But that is what the Competition and Markets Authority is for. They will investigate it. Similarly, proving abuse of a dominant position within a market is also a complex task. It's a job for economists, and a claim that was brought to prove abuse of a dominant position requires a significant amount of opinions from economists on what the relevant market was and what was the effect of whatever the behavior in question that is being criticized. There's a third point, which is that in both Chapter 1 and Chapter 2 prohibition cases, the overall loss and damage caused to victims might be very, very large, but the losses suffered by any one individual victim may be relatively modest. So those are the factors which make litigation of what would otherwise be quite a straightforward matter more complicated. But there are solutions to all of these, and this brings us on to the first piece of jargon, which it is essential to know if one wishes to pursue an interest in competition law. Follow-on actions. So the follow-on action, it's a colloquial term, but it's the procedure by which a victim of anti-competitive behaviour can claim damages if there's been a decision by the Competition and Markets Authority or by the Competition Appeal Tribunal on appeal from a decision by the Competition and Markets Authority that there has been anti-competitive behaviour, that the Chapter 1 prohibition or the Chapter 2 prohibition has been infringed. So why Competition Appeal Tribunal on appeal from a decision? Well, that's because somebody, the person accused of infringement, has appealed against that finding by the authority, and they've appealed against it to the tribunal, and the tribunal has endorsed the decision of the authority. The Competition and Markets Authority is a policeman. They say there has been infringement of one of the two prohibitions, and they do that they make an investigation, and they take essentially a bureaucratic decision. But that decision, unless it's appealed, stands, and if it's appealed and it's endorsed by the tribunal, it stands, and the courts are then bound by that if somebody wants to bring a damages claim. In other words, all the business about investigating secretive cartels and finding economists that can put together views on the market and the abuse of it is not necessary. It's already been done. All that the victim needs to do is prove their damages. So although a Competition Act claim might sound all very grand, in many cases it is just simply somebody proving their losses. It's not an unfamiliar concept. The majority of claims for damages before the Competition Appeal Tribunal are follow-on actions. It's not compulsory. You can start from scratch. They're called standalone actions, and you just prove your case. You just prove the existence of a cartel, prove the existence of an abuser dominant position, in some cases both, and prove your damages. But that is a significantly much more complicated piece of litigation, which will depend almost certainly very heavily on expert evidence. The law is straightforward, but the facts and opinions of economists tend to be the match-winning factors. Next piece of jargon, passing on. Nothing to do with passing off. Passing on is the situation on the slide. There's been a competition law infringement by A. So say A is a credit card provider that's been abusing its position in the market by charging inflated fees to retailers. As a result, party B, so in this hypothesis, a retailer has paid more for goods or services than it would, but the infringement had paid. The fees paid to the credit card company should have been less, but the retailer has overpaid. So on the face of it, the retailer has a claim against the credit card company for the amount of the overpayment. But as happens in real life, the credit card company turns around and says, well, you haven't lost anything because you passed on the charges, you, the retailer, passed on the charges to your own customer. You haven't suffered any loss. If anyone has suffered any loss, it's the customer, and therefore your damages are either reduced or extinguished. The burden of proof, significantly, though, is on the defendant, on the infringer or the alleged infringer. They have to prove that the costs, the increased costs for goods or services caused by the infringement were passed on by the retailer to the customer. The retailer themselves do not have to prove it. It's quite a difficult thing to prove, I understand. The third technical difficulty with competition claims, as I mentioned, was the fact that the overall losses can be vast, but the loss suffered by any individual person might be relatively small. That has brought about collective proceedings. There's two types of what might be called collective proceedings. Well, cases where there are multiple claimants. There is something called collective proceedings orders. So collective proceedings is in fact a term of art. And it is a United States-style class action. There is a representative claimant who is a representative of a class of victims. There's two types. There's collective proceedings where the victims opt in, and there's ones where they opt out. And the difference between, or the reason for choosing one or two of the other, is largely a question of practicalities. But this is a class action. The members of the class don't really have anything to do. There is a representative who brings the claim on their behalf. This is to be distinguished from something called umbrella proceedings. So umbrella proceedings are not a class action, they're just a procedural device. It is to deal with a situation when there are lots of independent claims, all overlapping and raising very similar issues. So collective proceedings, true class action; umbrella proceedings, case management device. So to take an example, currently going through the Competition Appeal Tribunal, there are a large number of claims arising out of anti-competitive behaviour by credit card companies. So these include, there's one certified collective action called Merrick's and MasterCard. So Mr. Merrick's is the representative on behalf of the class. So the class he represents is quite large. It's 45 million consumers. And the practicalities of all those 45 million consumers bringing their claims for overpayments on their credit card, which may be a few hundred, maybe a couple of £1,000 each, the practicalities are solved by a class action. Mr. Merrick's is not just any old busybody, he is a former chief ombudsman. Having said that, many people that seek the collective proceedings orders do appear to be just sort of interfering busybodies, but there are some perhaps more established figures that bring these claims. So in the same credit card litigation, as well as the official collective proceedings run by Mr. Merrick, so there were two proposed collective proceedings orders by special purpose vehicles that have been established to pursue claims against proposed defendants. So this is again, somebody putting together a special purpose vehicle, effectively, which is then to run the claim. That there were two proposed special purpose vehicles, and they were acting for the retailers. So Mr. Merrick's class action for consumers, special purpose vehicles for retailers. And that didn't exhaust the number of claimants. The potential members of the class is anyone who's ever used a credit card in the United Kingdom. So in addition to everything else, bearing in mind that the collective proceedings orders for the retailers has not been made, there are a large number of individual claims by the retailers, which have been grouped together under an umbrella proceedings practice direction. There's more to Competition Act claims than claims against credit card providers, although that has taken up a lot of time in the courts over the last year, and probably going back even further than that. Just to take some random examples before I wind up about the sort of thing that crosses the path of the Competition Appeal Tribunal. A case called Granville Technology Group. This was a follow-on claim by manufacturers of personal computers arising out of a price-fixing cartel for liquid crystal display panels. Michael O'Higgins, FX Class Representative Limited. As you might gather, this was a special purpose vehicle formed by somebody called Michael O'Higgins as a class representative for claims against Barclays Bank for foreign exchange spot trading cartel. Competition and Markets Authority against Apple. This made the newspapers. So the issue was, could the Competition and Markets Authority change its mind? They decided not to investigate Apple for restricting competition, remembering that the Competition and Markets Authority is the policeman and the investigator. So they'd taken a decision not to investigate Apple, and then they changed their mind and decided they were going to. And there was some litigation before the Court of Appeal decided they were perfectly entitled to change their mind. Mark McLaren Class Representative Limited, again, a class action, follow-on proceedings. This was a shipping charges cartel. This was the charges for putting cars on board ferries. As you can imagine, the potential members of the class that might have lost out on that were vast, but the amount that each individual might have lost was relatively small. BMW and Volkswagen against Competition and Markets Authority. This arose out of a cartel, or an alleged cartel, to do with recycling vehicles. The issue this year was, could the Competition and Markets Authority demand documents from Germans? Competition Appeal Tribunal said no. Court of Appeal said, yes, you can. Seems to me the important question is, it's all very well demanding documents from Germans, but what are you going to do if they don't give them? Anyway, in theory, they can be demanded, although there is going to be a decision of the Supreme Court at some point. Gutzman and Apple Inc. Was all concerned about collective proceedings, another follow-on action. And finally, the nec plus ultra of this particular niche of the law, a case called the Crown on behalf of the Competition and Markets Authority against the Competition Appeal Tribunal. Why, one might ask oneself, is the Competition and Markets Authority taking the tribunal to court? And the answer is because it thought, it rightly as it turned out, that the Competition Appeal Tribunal had exceeded its powers. The Competition Appeal Tribunal had said in a slightly sweeping way that the suspected existence of a secret cartel would never in itself justify the issue of a warrant in respect of domestic premises. Well, the Competition and Markets Authority, as I said, policeman, investigator here, didn't like that. They wanted if necessary, to get warrants in respect of domestic premises if they suspected the existence of a secret cartel. And the court said, yeah, that's fine. Right. Nothing more than a very, very quick introduction to the subject. But the point is, it should not scare anybody off. Some people might actually find it interesting. It is it's a handbook for the overthrow of Western capitalism, really, the Competition Act. It is designed to undo that which businesses naturally tend to do, which is to make as much profit as they can by any means. The job for the lawyers is essentially managing those procedural hurdles and establishing what are the levels, what are the damages suffered. All the difficult bits about market shares, margin squeezes, disguised barriers to entry, that's for the expert witnesses, that's for the economists to deal with. And if you're lucky enough to be on a follow-on claim, you don't even have to do that. Someone else has put in the hard work already. None of these concepts, i.e. overcoming procedural difficulty and dealing with damages claims, are in any way unfamiliar to any barrister, certainly any barrister working in the Chancery and commercial world. And I would say that if a competition-related issue crosses your desk, don't flee in horror from it, but simply embrace it. I have no idea how we get this work, but the Competition Appeal Tribunal is inundated with claims. There must be work out there somewhere. I don't know how we get it, but if that can be achieved, there's absolutely no reason why this should not be an area in which to expand and develop. Thank you all very much for coming. I'll take some questions if anybody has got them. I can't promise to be able to answer them. And to be honest, questions aren't really encouraged, but if anyone does have a question, I'll spend a couple of minutes trying to deal with it if I can. If not, I shall simply say thank you very much again, and I will log off.
Thank you, Jonathan.
Thank you, Jonathan. Really appreciated.
Appreciate it.
Really interesting. Thanks, Jonathan.
Don't actually know how to log on.
Thank you very much.
Right, Jonathan, can you hear me?
I can.
I had a question.
Yeah.
Which is on the evidence point.
Yeah.
I think you were saying that essentially it comes down to expert evidence.
Yes. So cartels are straightforward conceptually. So if somebody has come to an agreement with their competitor that they are going to cooperate on pricing and then artificially raise prices, that doesn't require any particular expertise. It is simply that like anything else, it's a conspiracy. It's difficult to find the evidence, and organised cartels are extremely organised. They've all learnt their lesson at the hands of the European Commission, who was very down on cartels generally, and they are done in secret, and extraordinary precautions are taken, which is just why it is difficult to prove them. And the investigations, European Commission investigations or Markets Authority investigations, take quite a long time, and they're quite, sort of secret agent type investigations. So that's factually straightforward. It's just proving conspiracy, but it is just difficult. Abuse of dominant position is almost entirely dependent on what the experts say. These are rarely straightforward monopolies. You first have to prove what the market share is, expert question. No, but there's an antecedent expert question, which is what is the relevant market? Then next expert question, what is the share of that market? And third expert question is what the alleged infringer was doing abusive. And none of these things are as straightforward. It is rarely obvious that having a plug shaped like that, as opposed to a plug shaped like this, is going to have a massively disproportionate effect on the market of excluding new entrants. But that was one of the issues in, I don't know whether it was Microsoft or Apple, but it was one of the issues in one of those type cases. The answers to abuse of dominant position questions are rarely obvious, and that's why experts are required. And they decide it's just one economist that just says, "Oh, this does not have any effect on the market," and another that says that it will. And like any expert, it's he's got the most coherent story to tell.
And if it's the individual, I know you said it's less likely, which makes sense, but if it was the individual company pursuing the cartel argument, how I guess generous, or how much are courts willing to order evidence to be disclosed? Because you'd only know that by, I guess, internal documents proving collusion and things like that. But that seems to can you just go to the court and say, this looks prima facie like a case, and therefore order disclosure to give me more?
Yes, the answer is probably yes. I can't think of a particular example. But the point about that last case, why was the markets authorities suing the appeal tribunal, is because they wanted the power, when they suspected a cartel, to raid domestic premises. Why do they want that? Because companies have got wise to the fact that their premises could be raided in effectively a glorified Anton Pillar type action. People from the Competition and Markets Authority turn up. They have statutory authority to do this, and they just go through the records and books looking for evidence of a cartel. So companies have got wise to this, and they kept all their records of their cartel at home, which is why the authority wanted to be able to, if necessary, raid people's homes. If they can do it, so can anybody else. If you had a sufficiently compelling case, you would get an Anton Pillar injunction in support of it, I would have thought.
Okay. Thank you. Very insightful.
Good.